Welcome back to the deep dive. Today, we're really digging into something absolutely critical for any business out there, whether you're just starting or well established. We're talking about how to build and, crucially, how to protect your brand's unique identity.
That's right.
We mean trademarks. And look, these aren't just some legal box ticking exercise, they're fundamental to your business's value.
Exactly. Think of trademarks as, well, much more than just a catchy name or a cool logo. They are genuinely powerful tools. They safeguard that identity you build. They foster real consumer loyalty. And honestly, they significantly boost how you're recognized in the market. And the really strategic part, it's their unique legal clout. They let you stop others from, just hopping on your bandwagon using similar marks and benefiting from the reputation you built.
Yeah, that prevention aspect is huge. So, our mission today really is to give you a clear shortcut to understanding how trademarks actually work. We're aiming to break down the 5 absolutely essential steps, not just to build a strong trademark, but to legally secure it. This deep dive should give you the insights needed to make smart, proactive choices right from the beginning. Okay, so let's start with the foundational question. Why do trademarks matter so much? At the most basic level, they identify your brand, they give you legal backing, and they grant exclusive rights to that identity. But there's a bit more to it that's quite interesting.
Yeah, the real power, the strategic edge, often lies in what lawyers call negative rights. Now, that sounds a bit technical, doesn't it?
A little bit, yeah.
But it simply means that owning a trademark gives you the legal right to stop others from infringing. Think of it like this. You own the only key to your unique shop in a really crowded marketplace. You decide who comes in and, maybe more importantly, who you can keep out if they show up with a knockoff key. So for you listening, a strong trademark isn't just, a nice bonus. It can literally be the thing that makes your business stand out instead of getting lost. It empowers you to defend your creation.
That makes sense. So to give everyone a really clear path forward, we've kind of distilled this whole complex world into a 5-step blueprint, a framework for brand protection. We'll walk through each one. First up is selection, then we'll cover registration. After that, utilization, followed by enforcement, and finally, maintenance. Think of this as your roadmap. All right, let's jump into step 1. Selecting a distinctive mark. Now, this is arguably where it all begins, and it's super important. The main do here, choose a mark that genuinely stands out. It's helpful to think about a sort of a spectrum of distinctiveness. At the strongest end, you have fanciful marks. These are basically made-up words. Think Kodak, Xerox, Exxon. They had no meaning before they became brands. They're kind of like gold standard because they're inherently unique.
Exactly.
Then you get arbitrary marks, real words used in an unexpected context, like Apple for computers. And then suggestive marks, which hint at a quality, like Coppertone for suntan lotion, without directly describing it.
That's a great breakdown. And those fanciful and arbitrary marks, they're inherently distinctive right out of the gate. And that means they generally offer the strongest legal protection. This is precisely why doing your homework, conducting a really thorough search before you commit to a name, is so critical. It's such a common mistake to skip this, and it can lead to, well, major headaches, cease and desist letters, maybe even costly lawsuits, all because you accidentally picked something someone else already has rights to.
And it's not just words, right? I think that's a cool point. Trademarks can be images, logos, even specific colors.
Oh yeah, sounds, smells in some cases, anything that functions to identify your brand specifically.
So what about the don'ts for selection?
Okay, yeah, the don'ts are just as vital. You absolutely want to avoid marks that are too descriptive or generic. Things like, I don't know, best coffee shop or speedy car wash.
Right, because anyone should be able to say their coffee is the best.
Precisely. They describe the service, or they're just common terms. They're often unregisterable for that reason. You can't monopolize everyday language. Trying to trademark something generic is, like you said, trying to own the word chair. It just doesn't work. And of course, picking a mark that someone else has already registered is a huge don't. Check databases thoroughly, including internationally if you have global ambitions. It prevents legal battles and, frankly, confusing your potential customers.
Okay, so let's say you've navigated that. You found a great distinctive mark. What's the next move? Step 2. Registering your mark strategically. The big do here seems to be start early, get that application filed.
Absolutely.
The sooner you file, the stronger your legal position and the less likely you are to run into disputes down the line. In the U.S., the main place is the USPTO, the United States Patent and Trademark Office. That gives you federal protection.
Right, nationwide.
But if you're strictly a local business, say operating in just one state, You might consider registering with your state's Secretary of State. Just remember, that protection stops at the state line.
Exactly. State registration is geographically limited.
And if you're thinking bigger global markets, then you need to look into filing in each specific country where you plan to do business.
That's a critical distinction.
Mhm.
USPTO registration protects you within the U.S., but it doesn't automatically extend elsewhere. And when you file, you have to be really, really specific about the goods or services your mark actually covers. The USPTO uses a system of 45 different classes. You need to pick the right class or classes for your specific offerings. They even have an ID manual to help.
Oh, okay.
Getting this classification wrong can mean your registration doesn't actually protect what you think it does. So this raises an important question. Why is precise classification so crucial? Well, because it clearly defines the legal boundaries of your exclusive rights. It leaves no room for doubt about what your trademark actually covers.
Got it. So precision matters a lot there. Now, what are the don'ts in the registration phase? What trips people up? First big one you hear about, just delaying it. Procrastinating on filing.
Huge mistake.
Yeah, it sounds like that can let someone else potentially sneak in with a similar mark.
It happens more often than you'd think.
Okay, second, don't. Ignoring official letters from the USPTO, these office actions, right?
Yeah, definitely don't ignore those. They're not suggestions, they're required responses. Usually there's an issue that needs addressing.
And another trap, thinking common law rights are sufficient. You get some rights just by using a mark, don't you?
You do, but they're often quite limited, primarily geographically to where you're actually using the mark and have built up some reputation. Enforcement can be much harder.
Right. And the last one, assuming buying a domain name or getting a social media handle equals trademark protection.
Yeah, that's a common misunderstanding. Domain names, social media handles, business name registrations, they are completely separate legal concepts from trademarks. They don't grant you the same exclusive rights to the brand identifier itself. And let's be clear, these don'ts aren't just, minor slips. They carry real risks. Delaying can genuinely cost you your brand identity if a competitor gets there first. Ignoring office actions, that's a fast track to your application being declared abandoned, gone. And relying only on those weaker common law rights, it's like building on shaky ground. Your ability to stop copycats is significantly reduced, especially outside your immediate area. If we connect this to the bigger picture, messing up these registration details can literally unravel the very brand identity you're working so hard to establish.
Wow, okay. So very clear risks there. All right, let's say you've successfully navigated selection and registration. Your mark is official. What now? This brings us to step 3. Utilizing your mark correctly. How you actually use it matters. The main do here seems to be consistency. Using the whole mark exactly as registered everywhere. On your website, packaging, ads.
Consistency is king.
And you have to use it in commerce, right?
Yeah.
What does that actually mean in practice?
Good question. It means you're not just sitting on the name, you're actively using it in the course of business. So for physical goods, the mark needs to appear on the product itself, or its packaging, or maybe point-of-sale displays where people buy it. For services, it generally means using the mark in advertising or materials related to offering and selling the services, and actually, performing those services under the mark, being paid for them.
Okay, so actual business use.
Yeah.
And symbols, TM versus SM.
Right. Use TM for trademark or SM for service mark for marks that aren't yet federally registered but you're claiming rights to. Once the USPTO officially grants your registration, then you can and should use this symbol.
That little circle R means it's federally registered.
Correct. It puts the world on notice.
Yeah.
And you mentioned bona fide use earlier. There's also a path to file based on a bona fide intent to use the mark, which lets you start the registration process before you've actually launched. But you will need to prove actual use later on. And what's fascinating here is how these seemingly simple actions, just using your mark consistently and correctly, actually build the strength of your legal claim over time. It demonstrates your ownership in a very practical way. Variations can dilute that.
So consistency builds strength. Now, what about the don'ts for using your mark? You mentioned not experimenting with different versions. Stick to the registered one.
Absolutely. Don't get creative after registration. Stick to the script, essentially.
And the other big one, letting your mark become generic. This sounds counterintuitive, like success being a problem.
It can be. This is called genericide. It happens when a brand name becomes so incredibly successful and common that the public starts using it as the general name for the product or service type itself. Think about how people used to say, make a Xerox instead of make a photocopy,
Yeah.
or ask for a Kleenex instead of a tissue, or even hoover the rug instead of vacuuming.
Right, or Googling something.
Exactly. If that happens, if your brand name just becomes the generic term, you can actually lose your trademark rights entirely because it no longer functions to identify your specific brand.
Wow, lose it completely.
It's a real danger. That's why companies often spend a lot on advertising, reminding people to use a Band-Aid brand adhesive bandage, not just a Band-Aid. They're fighting genericide. So this raises an important question. How can you ensure your brand name doesn't become a victim of its own success? It involves careful usage, educating consumers, using the mark as an adjective like Google's search engine, not a noun or verb, and consistently using those TM or symbols.
Okay, that's a crucial balancing act. So that brings us to step 4, enforcing your rights. This is when things get potentially confrontational, right? Someone's using your mark without permission. The big do here is be vigilant, actively monitor the marketplace, keep an eye out for potential infringers.
That's it, police your mark.
Think of it like patrolling your brand's territory. And if you do find someone stepping over the line, the usual first step is handing a cease and desist letter, basically telling them to stop.
That's typically the first move.
Yeah.
And consistent enforcement is really important. It demonstrates to everyone, including the courts, if it ever gets there,
Yeah.
that you take your rights seriously. If you consistently let infringement slide, it can actually weaken your ability to enforce your rights later on. It's like saying, it doesn't really matter that much to me.
Okay, so vigilance and action are key, but there are don'ts here too, right? It's not just about charging in. First, obviously, don't ignore unauthorized use because, as you said, that weakens your position.
Definitely don't ignore it.
But also, don't be overly aggressive. What's that about? Trademark bullying.
Yes, exactly. While you need to enforce your rights, going too far, sending overly aggressive or unfounded threats, especially to small businesses or individuals making fair use, can backfire. It can damage your brand's reputation, make you look like, well, a bully, and sometimes even lead to negative legal consequences or PR nightmares.
Ah, okay, so there's a balance to strike.
Absolutely. It's a careful balancing act. Ignoring infringement is detrimental in the long run. But overly aggressive tactics, or trademark bullying, can be just as harmful to your brand's standing and public image. If we connect this to the bigger picture, finding that right level of enforcement firm but fair is really key to maintaining long-term brand health.
Makes sense. Okay, final step in our blueprint. Step 5, maintaining your mark over time. So, getting the registration isn't the finish line. The do's here involve keeping things up to date, renewing your registration when required. In the U.S., you said that's after 5 years initially, then every 10 years.
That's right. There's a filing due between the 5th and 6th year after registration showing continued use, and then renewals are required every 10 years.
And you need proof, right? Proof you're still actually using the mark in commerce. What does that look like? Specimens.
Exactly. Specimens are evidence of use. For goods, it could be photos of your product packaging showing the mark. For services, maybe a screenshot of your website advertising the services under the mark, with the date visible. Links, pictures, access dates.
So keep good records.
Meticulous records are essential, and just generally ongoing vigilance. Your business might evolve, expand into new areas, or change its offerings. Your trademark strategy needs to adapt too. What's fascinating here, perhaps, is realizing how crucial this ongoing maintenance really is. It's not glamorous, maybe, but neglecting it is like letting a valuable asset rust. The legal framework, like the Lanham Act in the U.S. and U.S. PPO rules, demands this upkeep.
Right. So what are the key don'ts for maintenance?
The big one is simply forgetting. Forgetting to file that crucial proof of continued use between the 5th and 6th year is a very common way registrations get canceled unintentionally. Set calendar reminders.
Okay, don't miss those deadlines.
And the other don't is failing to adapt. Don't let your trademark registration become outdated if your business pivots or expands significantly into new product or service categories. You might need to file for new registrations to cover those areas.
Got it. Keep it current. Keep it alive. So let's kind of bring this all together. The value of really understanding and implementing strong trademark protection for your business, for your brand, it's just enormous. Getting a handle on these 5 steps, selection, registration, utilization, enforcement, and maintenance, it isn't just about legal technicalities. It can genuinely be the difference between, success and just fading into the background noise.
I completely agree. Trademarks are definitely not a set it and forget it kind of asset. They demand ongoing attention, smart strategy, and vigilance. Understanding these nuances of trademark law, it isn't just for lawyers. It's really essential for any business owner or leader who's serious about long-term brand security and growth. If we connect this to the bigger picture, effective trademark management is truly an ongoing strategic pillar for any growing business. It's fundamental.
So maybe the final thought to leave everyone with is this. What does all this mean for your brand's future right now? And thinking ahead,